Hi, good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series. Today, we are joined by Savitha, and Savitha is a graduate here from our program here and has been successfully working in primarily the area of landlord and tenant practice there and since becoming licensed. So, we're going to talk a bit about her career and her journey in getting there. So, Savitha, thanks for joining us. Perhaps maybe you can tell us a little bit about what drew you into law in the first place and a little bit about your background.
Yeah, well, JP, I'm not typically from a law background back in my country. I was from the HR background, but I always had interest in law from day one. And the paralegal program was something very interesting. And I just said, okay, I'll just, take it up and see how it goes. The more I was into the program, it started becoming very interesting for me. And I did understand because back in my country, there's nothing like a paralegal or something. It's more like a lawyer. That's it. So I was like wondering what would a paralegal do? And I always had that kind of a doubt in my mind. But then when I started going through the program, I actually felt the importance of the profession and how the access to justice play a major role, especially for us, for the paralegal profession, because a lot of the lawyers, of course, are expensive, and sometimes they're too busy to take up, small cases. So most of the time it goes self-represented in lower courts and in the board and everything. So um, they do not get what I felt was they don't get the right right outcome, even though they have a strong case. So that's one thing I felt about the paralegal profession. And the journey has been really good in trios. I had amazing instructor, and it was really good. And regarding my P1 license, I did not like wait for a year going and working as a legal assistant and then take up my license, because I thought if I have to do it, I have to do it right away, because everything is fresh in my mind. So let me just go ahead and try the licensing exam. So the preparation was you have to go through the material at least once. I know it is kind of overwhelming once you see the material because it's too big, and it's kind of a repetition of whatever you have done till now, but it's always my advice would be at least to go through it once. Even though it's an open book exam. I mean, when I took up the P1, I know now it is different. It's online, but when I took it up, it was in person, and it was if I'm not wrong, around 7 hours or something like that. So it was like first half 3.5, and the second half 3.5. That's how it was. And it was quite, even though it was 3.5, you don't have enough time to look through everything. Even though you take your materials along, you do all the, tab and everything, you will not have time. So most of the questions I felt was, what would you do as a paralegal? It was more linked to the ethics. So the statute question, yes, you can go back and look at it, but ethic, I would say you should have it right in the back of your mind when you're answering those questions. And it's pretty, once you are towards the end of the program, you have that knowledge of what a paralegal has to do, what are the rules they have to follow. Those things you will get it. So my advice for you is go through the material, and try to answer all the questions, and just be sure you know your rules of paralegal conduct very well before you attempt any answers. So that's about the P1 exam. Because I know now it's different, JP. Even if I go lengthy into what I took, I know it is totally different now, because even the course structure has changed. That's what I heard. Because when we took, it was like we had those lengthy, questions to answers and everything. But now it's different. That's what I heard. It's tuned to what the licensing exam is going to be. So I would say that's a plus point for all the students who are taking up the paralegal program now, because it's exactly a replica of how the exam is going to be. So it's kind of, they made it much more easier for you guys. So that's about my education and the licensing. Now about the practice. So whatever you study, whatever you do, until or unless you are in the field, you wouldn't know how to go about addressing each client. And believe me, each client is different. And in landlord tenancy board, even though you feel that, okay, the forms are pretty, easy to do. And you've even had clients come and say, hey, why are you even charging me this money? Because it's so easy. They don't understand one thing is it's not that easy. Even the calculation of each and every termination date is so important. Even a day which is missed, your application is just skipped out. So you have to be very careful, and you need to be, because the member follows the RTA and the rule black and white. So there is no gray area to it. There is no, roundabout to this procedure. You have to follow the procedure black and white. So that's how landlord tenancy board works. Because if your application, if your notice is perfect, then you at least have a good chance to win the case. And it's been a very good experience for me practicing in landlord tenancy board, because I've had multiple cases. I'm also learning, in the sense, each case is different, and you tend to go back and do a little bit of research. Okay, this is kind of unique. What should I do about it? Do I have a case law similar to this? So that's how you tend to learn. And even I have seen that people have a perception that, LTB, I mean, landlord tenancy board is a very easy this thing, but don't take it that, don't take it for granted. You will have to go through case laws for that as well. Because sometimes, when it is a difficult tenant or a difficult landlord you're dealing with, you will have to mention the case law in front of the member. So just make sure you do the procedure as per the act, as per the rule. And that way you'll be doing, you'll be helping your clients. And I also practice in small claims court. Now that's a different ball game, because advocacy in small claims court is totally different when compared to landlord tenancy board. In landlord tenancy board, it's a little bit easier, because most of the time what happens is, even though you're there as a representation, you're talking, still some member would say, hey, I want to listen to your client talk. I don't want just you talking. I want to hear his perspective of whether he is agreeing to this. So that's why I make sure I have my clients also on the call. I mean, it's all virtual now. So I also ask him to be on the call, so that he's able to, give his perspective, saying that, yes, I agree. I have already discussed with my representative and I agree to this. So that is one thing about the advocacy in landlord tenancy board. But when it comes to small claims court, the judge is he's totally a neutral party. He doesn't know anything. It's my story versus the opposing story. So that has to be more elaborate, And I'm sure you must be learning about drafting of the claim and everything in in your course. So what I find very challenging with small claims court is uh, each client comes to you in a very unique demand, saying that, oh, okay, I have had this problem. Why don't you just put a claim for 10,000 for my pain and suffering? You got to make them understand, hey, we cannot just put pain and suffering. You have to back it up with evidence. And small claims court is all about evidence, because you're telling your part of story, you need to back it up with the evidence. So that's my experience in small claim court, where it's been difficult sometimes for me to explain to the client that, no, I understand you've been through this, but what is the loss you have suffered? Show me some, you need to quantify that. So that's one thing you need to watch out when you're talking to your clients, saying, you're not totally discouraging them, but at the same time, you're making them understand that it's not, you're making them understand that it's not all about your emotions, but sometimes you need to have evidences. You need to quantify those emotion as well when it comes to small claims court. So that's what I experience, and that's what I follow when I'm talking to my clients. And that's about it.
All right, Savitha, let's kind of go through some of that and maybe have some more detailed sort of follow up there. I mean, it's funny you mentioned about drafting, and sure some of my students that are getting ready to put together a plaintiff's claim for a small claims class that they're in. Perhaps maybe you can share a little bit about that in terms of what you would include there, and the importance of having the evidence, as you pointed out, because you can't just put 10,000 for pain and suffering if there's no medical reports or any evidence to that, right? So maybe you can tell us a little bit more, when you do draft a claim, what is important to put in there, and as well making sure you name the right parties and everything like that.
Yeah, so in plaintiff claim, main thing is it's your story. So you need to be clear on what you're expecting from the client, expecting from the defendant. So first, put in the calculate your whatever damages and put in the damages. You need to, because only if you claim it, only if you put that in your claim, you're going to get it. Otherwise, judge is not a person going to, oh, I see you have these things, I'm going to grant you. No, you have to plead it. Until you plead it, you're not going to get it. So you make sure you do the pleading in a way saying that, okay, this is what the losses my client has suffered, the plaintiff has suffered, and this is quantify it and go with that. And naming the party is also very important. Sometimes what happens is the defendant can be a company, a sole proprietor. So you would want to include even the person as well as the company, because sometimes you just go against the company. All they can do is they can declare bankruptcy. Your client is not going to get anything. So try to pull in even the person behind, because he's a sole proprietor and he's representing the company. So try to put both as defendants. That way, if the company declares bankruptcy, you can go against the person for execution. So these are basic things which you need to do before you even start a claim. And then your facts. Don't go by saying too many things. Just go by exact, okay, this is what happened. Just summarize it saying, this is what happened, and these are the disputes. Just try to be concise when you're saying each facts, material facts. And then if you're claiming, say, 30,000, if you're able to break that down, please do that as well, because that makes it very easy for the judge to also understand where you're claiming this 30,000. Because if you just say, I'm claiming 30,000, he'll be like, what are you claiming? So when you're doing that, try to break it down, saying, okay, this was 10,000 invoice from whatever such and such a date or whatever. Try to break it down as well in the body of the claim. So this is how a pleading has to be, because it has to be in such a way that you have covered all the areas which you're trying to claim from the defendant, and you have you put forward your story in a right way.
And what about if you're on the other side, if you receive a claim, and how do you respond to a claim?
Yeah, so now I did have one unique case which I'm right now dealing. I have a settlement conference in March. So what has happened is the defendant, there were 3 defendants: the husband, wife, and the company. Now the company is no more with the husband and wife; they sold it. So when I am going to, because I'm just representing them, not the company. So I will say I'm, the defendant 1 and 2 is the one who's denying this claim and everything. But when I'm serving it, I have to serve it even to the person who is named as defendant 3, which is the company. That's very important, because then otherwise your defense is not accepted in the court. So that's one thing I'm doing. I just wanted to kind of, bring that up here. And in your defense, you have to tell your part of the story, saying that, hey, this is what the claims say. What I follow is I follow point wise. I say the defendant denies 1, 2, 3, 4, or defendant acknowledges whatever probably the party's name. You have to say, yes, I acknowledge this is what it is. So you just go point wise, and then you tell your story saying that this is what has happened. This is not something I owe. So that's how you tell your story. First, try addressing the claim, and then tell your story, and then you say, I would request the judge to dismiss this claim. So that's how a defense should be.
So you mentioned settlement conference. I know we're talking about small claims here, so let's just continue on with it. You mentioned you have a settlement conference coming up, and as well with matters potentially going to trial. What has that been done? What is that like virtually these days? I don't know how you found settlement conferences virtually, and certainly I know you have that one coming up, but is it any different than being in person? Because one of the things that we're doing in my course in a couple of weeks is a settlement conference, and it's going to be done over Microsoft Teams. I don't know if you use Zoom or whatever, but technological differences aside, what's different, if anything, settlement in person versus virtually?
It's not much difference, I would say, at least settlement conference, because trial right now, I haven't had any till now, because it's all been like kind of settled in settlement conference itself. So settlement conference, I mean, you will have both the opposing representative, the judge, and your respective clients as well. So it's not, I don't see there's much of a difference, except for that the in-person, the contact. That's the only this thing. I don't feel there's much of a difference as such in settlement conference. And last time I did have one settlement conference where the judge was pretty, he was pretty clear on what he was talking, and he was pretty clear on the case as well. Because sometimes what happens is the judge reads through the case, and he comes like your claim and defense, and then he comes prepared. But there have been chances where they don't read through the whole claim. So you will have to repeat the whole thing in front of the judge. So this particular settlement conference, he had roughly gone through it. So we had to literally tell our each one side, like the plaintiff had to tell what the claim was about, and we were from the defendant. So we had to explain why we were defending and everything. So one thing I noticed was the settlement conference judge sometimes says that, hey, this is not something which, if you go to trial, there would be double the cost. So try to settle it here. Because this particular case, he went on right away saying that this is what I feel maximum you're entitled to. You cannot be entitled more than this. So that's one thing I found it very interesting, because we had the same case. We had an in-person settlement conference where nothing happened. They just said exchange of document and that's it. But this virtual one, I don't know whether they're trying to kind of, catch up on the backlogs and everything. They're trying to make it much more, easier for the parties, saying that if they feel that this should go to trial is when they're pushing. Otherwise, they're just saying that, hey, this is what I feel. Even if you want to go ahead. But my personal opinion is this. That's what the settlement conference judge said. So it was like.
Now let's switch over to the other area of practice, the landlord-tenant board. And you were mentioning kind of sometimes you have to be ready to have your client speak. How's the landlord-tenant board been operating in a virtual environment, and how have you found matters there before it in terms of being ready to advocate for your clients?
Oh, a landlord tenancy board is totally a whole different ball game, because it's more like, it's they have been hearing, JP, you will not believe, they're hearing every day around 100 cases every day. It's been so very crowded. And now what's happened is, most of my cases, what we do is, instead of waiting to go in front of the member, we'll say, okay, let's try first talk to the tenant. So most of the time, if we feel that the tenant is, obliging, we'll just go ahead and try to resolve it before the mediator, rather than going all the way till the member, because it is pretty, overwhelming. Each session is so overwhelming. So it has been a challenge. Also, there have been challenges where, either the member is not able to hear us. Those challenges are there. And especially if the tenant is unable, he's not technical savvy, and he's not able to get in and talk. It's been a big challenge with landlord tenancy board with a virtual hearing. And because they even sometimes come and say, hey, I'm on the phone, I'm not able to send the evidence, even though they are supposed to send the evidence like 7 days before. So these are some challenges which we are facing in the virtual background. Because in person, it is totally different, because even if they have it, they're supposed to show it. They show the evidence. Now they just get away with this thing saying that, oh, it's all virtual, I'm unable to do it, I don't know how to do how to operate this and all those, so it's been different for sure.
And how do you find that appropriate balance, right? I mean, in terms of, you want to provide access to justice, right? People to go through this, but at the same time, you need to move those matters along and be fair to the other side, right? I mean, as much as you want to allow them to submit whatever those documents are, I mean, if there's a deadline, there's a deadline too, right? How do you think, in terms of grappling with that we should be finding the right balance in maintaining access to justice, but as well maintaining that for both parties, or to go forward? What can be done about that?
So I'm sorry, JP, my kids were screaming in the background. Yeah. So the thing is, even though the rule says that they are supposed to exchange the documents, sometimes the member, they are a little bit, how do I put this? How do I say? It's more like a soft corner towards the tenant, because they feel that, okay, they sometimes some tenants can't even speak English. So they are more sympathetic towards such kind of people. But that will kind of, it kind of, have this unfairness towards the landlord, because just because the tenant is not able to speak and he's not able to provide the evidences, why should my case be heard differently? So that's something which I feel the member should consider, saying that the rule is something which need to be followed. Either give another date of adjournment or another date of hearing, or I would say that they need to give them probably a half an hour time or something to just sort it out and send it to the landlord. So what happens sometimes, JP, another thing I've noticed is some members say that, okay, you can send us the evidence by end of day today, but the party is supposed to send it to the landlord as well as LTV, and sometimes they fail to do that. So we are at we are at loss because we are not getting to review the evidence, because that is what the access to justice is about. We need to review the evidence before we say, okay, we deny this evidence or we accept this evidence. We need to voice out our opinion as well on the evidence that has not been provided to one of the party. So that's one thing which I feel they need to do something about it, because it's a virtual background. They need to have some kind of a rule specific to the virtual background where there is a discrepancy in the exchanging of evidence. And that's one thing I feel should be addressed, because right now we don't see anything going in person, at least for a year or so. So you need to do something about the rules pertaining to these technical challenges.
Great, and it's obviously difficult there when you're looking at moving things forward, but again, wanting to be a little flexible with the rules, but again, bend, don't break them type of thing, right? So
Yeah.
I do want to go back, maybe all the way back there, and so from what we started there with in terms of getting into the program, and certainly students will love to hear from people who've gone through the program, because anytime I bring on anybody else, they're like, oh well, they don't know what it's like to go through our program. So I did want you to share a little bit about the first of all, you made that decision. You didn't have a legal background, as you said, back home.
Yeah.
So what was it like making that transition from starting in the program and getting through, the exams and the assignments and everything? How did you find that in terms of getting from where you were and starting with this thing that was completely new to you in the first few months?
So I would, when I'm talking about that, I would like to compare the education system, what I came from, to here. There, it was more like, textbook kind of an education where you have just been given a set of this thing and you just have to, go by that. But in the paralegal program, when I took the paralegal program, all the assignment was something which is designed for you, so that you as a paralegal, how are you going to address this? That is what I felt, because it wasn't something like we write it down from the book. No, there have been case studies which are given to you, and that is where based on the case study is what your assignment is going to be, right? So that is one thing I found it very interesting, and it made me learn through how to address the case study, how to even my writing skill, I would say, improved over time. Because it in back in my country, I mean, it was just that, okay, this is given to us, we just write based only on that. It's kind of streamlined only on that particular. But here in paralegal program, when you're given a case study, you will have to do a lot of other research apart from the book. It's not just the book. You have to do research apart from the book. And even for the legal research subject, where we had to do the case laws and everything, So this kind of makes, it's been designed in such a way that it is going to help you in the future when you start practicing. So it kind of helped me think like a legal professional. So I thoroughly enjoyed the whole program. It was very good. And the subjects were challenging. Some of the subjects were challenging, but the instructors made it, made us feel comfortable. They were approachable. So I was able to, I was able to perform in the program well, and I I enjoyed it. And even the claim, whatever, I think small claims court, they have this assignment of doing a plaintiff, drafting a plaintiff claim. So that's also very important. You will learn how to do it. But whatever said and done, once you start practicing is when you will learn more about the field, because that's the program is one thing, but the profession, when you come to it, and each client is different, it's going to be, you will have to adapt yourself. So that's what you need to make sure when you're in the program. Also, you need to adapt yourself to each each assignment in a way that, oh, why don't I do it a little bit different? Why don't I write a little bit different? So that's one thing I always used to I learned in this program.
Now, to build on that, I know the exams are different in terms of online versus in person, 7 hours versus 4 hours. But I mean, the basic format with it being open book, all multiple choice is still there. And I know you've helped students in the past to prepare for the licensing exam. So anything you can share? I know there's students writing in 2 weeks from now, and they're getting all nervous because the exam date, or less than 2 weeks now. I think they're about 10 days from now. Anything that you can share from going through that experience about dealing with your nerves and answering questions that are open book, right? Now I know a lot of people come from other countries. I was just talking to someone yesterday, and they're like, "Oh, open book. I mean, completely different than having to memorize everything in a closed book exam." So, what worked for you, and what can you share for those who are about to write that exam in a couple of weeks?
As I told you earlier, that just go through the material once. Try to make points, which is very important. Like for the statutes and everything, you will anyway have to look into your book, because that's not something you can have it in. Even today, if I have to look into some particular act, I have to go back and look at it. I don't have the whole act in my mind. So that is one thing. Try to do the tabs and everything for those statutes. But when you're reading through your whole book, read it like the way, like what you would do as a paralegal. And even answering exam, I'm telling you, that's what it is all about. What are your rules of conduct is what is very important when you're writing your exam. Most of the question would be based on that. So make sure you've read your ethic books very well, and make sure mark all the statutes and tab it properly. So that would be more than enough. And JP, I tell you, open book exam is most difficult compared to closed book exam. That's what I felt.
Yeah. So why is that the case? Because I mean, I think there's always this misconception with students, whether in the paralegal program, whether in the licensing exam, or even in other programs and places I've taught, where they think it's open book. And then, I mean, I've even literally seen students that would open the book up for the first time on the exam thinking, no, the answers are here, I'm going to do well. And then they're surprised when they don't. What makes it more challenging than a closed book exam?
So the closed book exam is more like, okay, this is what the, for example, like physics, they'll say, okay, what is the law of whatever they'll say, and then you just have to explain it. But here, even though it's an open book exam, the questions are designed in such a way that you cannot just waste your time just going through the whole book. That's not going to happen, which means you should understand the concept. That's more important for you. It's not just, okay, dispute resolution. No, that's not something you just can go and search what is dispute resolution, but you should understand what is dispute resolution. So you need to understand that concept very well. Like, for example, I'm not able to get any other topics like um, uh, in small claims court, for example, they say what's liquidated damages. Okay, you have a definition of liquidated damages, but you need to understand what is that liquidated damages. What do they mean? So that is what I feel in an open book. The questions are designed in such a way that they ask you that about the topic. It's not like what is liquidate. They will ask you in such a way that before you even understand the question, you would lose time to go search for it. So that's why whatever you're learning, you need to understand the concept. That's more important for you. What each topic, what each heading means. Like even when you're doing a lecture, you just put those the bullet points. That is, that's very important. The reason being, those are the essence of that topic you're talking about, and that is what make you understand, okay, this is what it is. Okay, dispute resolution is this, is basically a different way of resolving a conflict. So this is what is important when you're when you're learning anything. And open book, the questions are going to be designed in such a way that it's not going to be a straightforward question where you can go and look back. So that's the difference I find between the closed book and the open book exam.
Yeah, certainly. And they're not just going to be find the answer, right? You're going to have to, obviously, if it's open book, you can find it there, but it's how to apply those concepts that I think a lot of people, especially when, the advice you have about think of what you would do as a paralegal. Well, that's exactly what, the law study wants to make sure that, because you're going to be a paralegal if you pass that exam. And what would you be doing in those kinds of situations? So it is important to be able to make those connections and certainly apply there. And what about just the exam in general in terms of dealing with anxiety and dealing with the stress and the nerves? And I'm sure for you, once you had finished it, then you're waiting another 6 to 8 weeks for the result and all of that. I mean, how do you handle all of that? I mean, especially for you, right? You're coming in, you went into a program, you weren't had a background in law, you excelled through the program, you write this exam. That's really all you're waiting for is that result, because once that result says pass, you can get into this career. So what was that process like for you?
I was a bit anxious, but I was confident when I answered my exam. And the day of exam, believe me, it was quite overwhelming. It was a bad weather too. I even called up and asked, do we have the exam today? Because I think it was ice rain or something on that day. It was a very bad weather. And we had in-person exam. And in-person, believe me, it's totally different from the online. Because online, you're at the comfort of your home. But in person, it's not like that. There were certain, stringent rules over there. And the worst part, we didn't have a cafeteria over there, which was like the worst thing. Even though my head was banging, I couldn't even go and get a cup of coffee. So it was quite overwhelming. But at the end of the exam, I said, okay, finally I've done it. So let's cross our finger and wait for the results to come. And I was super excited to see my results. And uh, one more thing I'd like to tell you is, initially I had that this thing of, okay, should I go work in a law firm or should I start my own practice? But then I said I took up this program because I would want to be independent and help the public. So I said, okay, I'm going to directly jump into it. I do have a very good mentor who's been helping me throughout, who's been mentoring me throughout. So that has helped me a lot. And today I'm pretty confident in all my landlord tenancy issues, because I know now if someone comes to me with an issue, I know what is the best alternate for him to go ahead with the issue. So that's my confidence level right now. And yeah, it's been a wonderful journey, I would say, from the paralegal program to now. It's been really wonderful program. I mean, wonderful journey for me.
Yeah, I mean, I think it's really important that you went through that process, because I was going to ask in terms of just starting up and going right into practice, but I think you highlighted the really importance of mentorship,
Yes.
because again, if you're going to be your own sole proprietor there, you need to have those people, or the Law Society as a coach and advisor network as well, but you need to have those people there in your corner to help you. And then once you gain that knowledge, then it comes second nature, as you're saying, with the landlord tenant board. You know all these issues, you understand it a lot better than when you were first starting. So anything else from opening up your own practice that you can share for students who would potentially be going that route and a little worried about, is that the right decision to make? Besides mentorship, what else do you need to know about being your own boss that you can share with us?
Yeah, so basically, one thing, I mean, especially the main this challenge in your own practice is dealing with clients. Believe me, you will get all kind of clients. I'm telling you, they will just come say, today please sue this person, I cannot take him anymore. So you need to have that patience to talk to those clients. And you need to, if at all you're in doubt, you can always say, okay, you've told me all these things, let me get back to you. That's the best way to do it, rather than giving a wrong wrong advice. So I would say, try to you need to learn how to deal with your clients. That's the first thing, because that is your starting stage of any case. So you need to talk to them in a way, make them understand. And do not even in slightest of this thing say that, oh, your case is a very good case, you might win. No, never do that. I'm telling you, the client is just going to sit on your head and say, oh, you told me, now what happened? Because ultimately it's the member. If it is a LTB case, it's a member's decision, and if it's a small claims court case, it's the judge decision, and that is something you cannot influence. So the best this thing would be to say is, yes, there are some positive points, we'll go ahead with this positive points and we'll see what happens. We'll try to fight for it, we'll see what happens. That's it. Do not even go ahead and tell them that, oh, very nice, you have a very strong case. No, don't ever make that mistake. So that's something you're gonna learn over a period of time. It's not just going to come. Even if you work in a law firm also, you have to learn it. You need to interact with more and more clients. That is when you will get to know how to deal with them, how to stop them, where to stop them. All these things you will only get to know once you have started interacting with them. So that's important. And for my practice, yeah, as I said, mentorship has played a big role for me. And another thing I would say I would recommend is, try and learn from others as well. There's no harm. If you have a friend who's a lawyer who's practicing, you just say, okay, can I come one day to your office just to see how you interact with clients? There's no harm in saying. You can always go and you can observe. Now, of course, there are no courts open. Otherwise, I would suggest go to the court and see how each cases have been handled. That's another way you can learn, because this is something you have to learn, irrespective of whether you work for a law firm or you're going to open your own practice. This is something you need to develop. So there's nobody who's going to come and train you. Even in a law firm, I have not seen any lawyer having time to go train somebody, saying, hey, you have to talk to them like this, you have to deal with a case like this. No, there also you have to learn by yourself. So that is one advice I'd like to give to everyone, saying that you have that open mind that yes, I need to learn, irrespective of what stage of a practice you are. Even now, I've been practicing for more than 2 years now. Even now, I don't mind going and learning. There's nothing, no harm in learning. So pick up these things from everyone, those positive things, how they handle a difficult case. Try to pick this up. This is going to help you when you're dealing with something similar.
Perfect. Now, Savitha, thank you so much for taking the time here and joining us and sharing about your story, your journey there from being a student in the paralegal program to finishing the program and then preparing and becoming licensed, and then talking to us about the Landlord and Tenant Board and small claims court in particular. And I mean, I'm glad actually, and I hope my students who are here appreciate this, because today we were going to cover drafting claims and we were talking about client relations, and you've already given us a great overview of those 2 points. And it's funny because again, we didn't really have anything planned out, right? But it's funny how it works out that way, that there's a lot of value in listening to people who are practitioners, because you're getting that practical side, right? That I think you only can learn so much in school, as you mentioned, but then when you get out into the field, by putting things into practice, you learn and you gain from every client. Everything's a different experience there. So I was wondering if you have any final words of wisdom for us here in terms of remembering back to where you were a few years ago in class, I guess you were actually in a classroom, and what can you share with the students? And thanks so much again, and wish you all the best with your practice.
Thank you, JP. Thank you for giving me such a wonderful opportunity to speak to all the upcoming paralegals over here. So my word of wisdom is that enjoy what you're doing. Enjoy. I mean, I just want to tell you this, that one of the lawyer whom I work along with, he just told me that it looks like you have intoxication of law. I said, probably yes, because I'm always enthused to go through something new. I'm always enthused to go through legal research, because these are things which makes you learn how each situation is being dealt with. So I would say you need to really enjoy this. That is only you. That's the only way you will be able to succeed. Because if you feel that, oh, what is this? Why am I doing this? The moment you feel that, you may not be able to give your 100%. Take each step as a challenge, and enjoy doing it. That's what I would like to tell them.
Perfect. Some great advice there for everyone. And thanks again, Savitha. Again, all the best again with everything, and take care to everyone, and see you next time.
Thank you. Bye-bye.